part of the family come on out, so I just send people on the.
I didn't know that.
behalf of George Pino, who is President Howard Strudnick, together with Mark Shapiro, Edward Armelino, Janelle Gomez. Good afternoon.
Good afternoon. Annalise, would you please swear in Mr. Pino?
Please raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
All right, let me go over some ground rules for everyone in the courtroom. See, we're a full courtroom. During the course of the proceedings, it's critical that no one takes a phone out, no one has a phone on. You can leave your phones on vibrate, please, but don't take them out. There'll be no photographs, there'll be no video recordings. Please abide by these instructions. Second, I'm going to ask if you could, because again, we're so filled in here, but it is going to check, see if you can bring the temperature down. But please, ladies and gentlemen, try to keep your movement to a minimum in terms of in and out of the courtroom, because it gets also distracting. People, you know, trying to work their way in and out of the rows. We will take breaks. We're going to be, I have some matters to address with the attorneys at this time. Renee's going to go up and get our jury. And Renee's going to get our jury. And while he's doing that, I'm going to address some matters with the lawyers. Ladies and gentlemen, it's also extremely important. Please, the jurors will all be wearing juror badges to identify themselves as jurors. Even if you might not recognize them as a juror in this case, if you see someone with a juror badge, please don't go up and speak with them. Please also, if you're having any conversations about this matter, make sure you look around and see that nobody wearing a juror badge might be near you and be able to overhear those conversations. So please find private places. I urge you to have whatever conversations you wish to have on anything about this case in particular. Okay? And please be very mindful, though, of the fact that it obviously takes time to select a jury. We don't want all of the work that we have all done so far to be for nothing. And all of you are, because this is a public forum, you're entitled to be here, but all of you are part of ensuring that justice is served and that the proceedings are fair. And to ensure that, again, please, no contact with any of the jurors, not even a hello, which can be misinterpreted. You see a juror, they're in an elevator with you, get out of the elevator. Again, avoid all contact. When we take breaks, because you're bound to have some type of view of jurors that might be on this case. Again, please stay away from them. Okay? I urge you all to do that so that we're going to be in session for upward of 2 weeks. So it's going to require everyone's attention while you're at this courthouse, attention to that matter. I ask you all to do that. In addition, the proceedings are going to be televised, and there are already rules that I have discussed. We have our Zoom on. There is no recording. There are no photographs. And if you're in the Zoom, as I'm making these statements, please make sure you keep your camera off, no comments, and keep your audio off. My judicial assistant is going to be monitoring the Zoom, and you will be removed from the Zoom if you violate these rules.
sequestration. I know that that would mean that witnesses will not be able to be in the courtroom or observe on Zoom or on any live stream, nor will they be allowed to speak with each other about the case. Of course, that has to do with evidence, so anyone that's here, and I would not ask anybody to be excused from the courtroom for opening statements. But once the proceedings begin with witnesses testifying. I know we touched on the issue of the fact that Cecilia Pino, Mr. Pino's wife, is listed as a witness, both by the state and the defense. Unlike family members of the deceased that have a constitutional right under Florida's Constitution as well as Marcy's law, they have the right to be here. I will tell the court I do plan to call Mr. Fernandez, Lucy's dad, and do not intend to call Mrs. Fernandez, her mother. I don't know if the defense is going to wish to call her. I was asked to accept service for subpoenas for both of them, which I have done. They're both present. I would like to inquire whether or not the defense is going to try to exclude Mrs. Fernandez from these proceedings.
No, we won't.
Your Honor, the next thing has to do with some discussions that have been had over the last 24 hours or so. I've had conversations both with Mr. Shrevenick as well as Mr. Shapiro.
If I could just interrupt. Those conversations need not be part of the proceedings today.
To the extent that I will reiterate that the state is still willing to have an open mind. If the defendant wishes to pose any kind of plea offer that would be acceptable, his attorneys know the range of what the state would be willing to accept. I'm still willing to consider that. If he does not wish to do that, I would ask if Your Honor would make an inquiry.
Well, we can certainly, if the court thinks it's appropriate, I can convey what the state is offering.
I have not made an offer. I've indicated a bottom line of what the state would maybe accept.
I'm not going to make any inquiry at this point.
Okay.
Unless there is some further discussion that I need to become involved and make it on the record inquiry of Mr. Pino, I'm going to decline to do so.
I just would not want to have a situation where if he were to be found guilty, that he would make an allegation that he actually wanted to engage in some type of negotiations, but for whatever reason wasn't able to.
I think it's clear.
Okay.
What else?
Your Honor, there was a motion in limine regarding a couple of photographs of Lucy Fernandez at the hospital. I have two photographs that I intend to introduce into evidence today. They were previously provided in discovery, and they were part of a large email list of the state's evidence. I have copies of those available for the court to review because I would be introducing them probably through the state's first witness, so that in order to have a smooth transition from openings into that, I figured this would be a good time to address that.
Let me ask you, getting back, working backwards, on the opening statement, how long do you believe the opening will be?
Maybe 45 minutes or so.
Depends how you go.
Similar.
So it's likely that after the opening statements, we probably take a break anyway, so hold off on that. So you're not going to use anything, if you have demonstrative, that's the next thing. If you have demonstrative aids or anything you intend to use during openings, that I'll look at now.
I've shown all of the demonstrative aids I plan to use for opening. They've all been pre-marked. Mr. Shrevenick advised he has no objection to the state using them.
That's true.
Can I see them?
Of course. May I show them, though, in order because I don't want to? Of course.
those going to be admitted or not?
All of them I anticipate will be amended.
Right.
Such a non-profit goal, see if we get a little ventilation.
Okay, let's do that.
These are images of the boat post-crash while it's still submerged, and a enlargement of the defendant's written statement.
Okay.
And Judge, just so I don't have to keep running back and forth, would Your Honor allow me to just line these up along there?
Absolutely. Anything else? State.
Yes, Judge. I sent over to the defense two proposed stipulations to sign and enter into the record. One has to do with the body-worn camera footage of Mr. Pino being interviewed by Lieutenant Thompson, where we agreed to redact the statements that involved the request for or the decision not to provide a sample of his blood, and also one that represents the statement that the defense indicated they would agree to, which is that on the day in question, Mr. Pino's vessel was in proper working order.
Okay.
So at some point we can get those signed and admitted.
Okay.
And the last thing, Judge, is just I don't know if all of the defendant's family members were here when I raised a concern about the amount of displays of affection between the family and Mr. Pino. I understand fully that they want to support their loved one, and I have no problem with that. But I think that public displays of affection, like what we've seen thus far, is not appropriate in front of the jury, or even in the hallways, things of that nature. I would just ask, and I've advised everybody on the side with Ms. Fernandez and such that throughout this trial, they must maintain proper decorum, no outbursts, no anything like that, and they're not to have any interaction with any of the jurors. But I just want to make sure that there's no displays that are inappropriate for a courtroom.
All right. The only thing of that I need to respond to would be the last comment as part of the rules of the House for everyone. It's an understatement that this is a difficult proceeding for probably everyone in the courtroom, for whatever those reasons might be. This is a court of law, and I expect everyone will conduct themselves respectfully, appropriately during the proceedings. If there is something that is disturbing or upsetting, please go outside. Avoid shows of emotion. Again, if that happens, it makes it not only very uncomfortable, but it's inappropriate for a jury to see any of that. And so I expect that kind of conduct from everyone in the courtroom. Please, no public displays of affection within the courtroom. Again, if you see anyone with a juror badge outside the courtroom, avoid them. And if you're in a private place, then it's much different. Okay, so anything that potentially could be causing influence to any of the jurors would not be proper. And I have Renee here, obviously monitor the courtroom. I don't anticipate having any difficulties along those lines. Everyone can be used to respect each other's
collided with one of the markers at a slow speed. The 8-year-old son was ejected, sustained a brain injury, significant brain injury. There was media attention surrounding it, at least on Local 10. And then there were the postings by folks about this case, people trying to correlate the event, tragedy of this weekend, having nothing to do with Mr. Pino, and making comments about Mr. Pino. I want to make sure that our jury has no exposure to that kind of sarcastic remarks by the public to a tragic event. So I'd ask the court, when the jury is available, that you would inquire whether they've seen anything, even if it's not directly about the Pino accident. There was this other accident over the weekend.
I'm gonna, as I will do every single day, make that inquiry just overall about any information about this case or anything else that might be seen related.
Thank you. We had proposed last week, I had suggested to the court when we were doing voir dire that the court should consider instructing the jury on the nuances of the charges of manslaughter and vessel homicide. The court had read a few sentences, but those sentences didn't define the mens rea elements of the charge. For example, manslaughter requires one, that there's a death, and second, that the death was caused by the culpable negligence of Mr. Pino. But the term culpable negligence, I submit, should be explained to the jury now so that they can process the facts and the evidence through the lens of what the law requires. Likewise, with vessel homicide, the court gave a preliminary instruction during voir dire, I believe, but did not define the term reckless manner. And the concern I have is that this is a case that, to many people, there could be confusion between civil liability and criminal liability, and I understand that the court has made a great effort to help the jury understand the difference. But in going into this trial and processing the evidence, we would ask the court to consider giving some more in-depth instructions now. So we submitted one for manslaughter, one for vessel homicide. And in doing that, what we did was we grabbed excerpts from the case law and we provided it to Your Honor in a red-lined submission so you could see the verbatim quotes we took from the cases that we found. Now, one thing that's becoming quite evident to us is that the difference between culpable negligence and recklessness is terribly murky. And indeed, the Supreme Court of Florida in McCreary made it sound like culpable negligence, which is the manslaughter standard, should be a greater offense than reckless driving leading to death, the so-called vessel homicide charge. And of course, that would mean that if Mr. Pino is acquitted of the vessel homicide charge, he should necessarily be acquitted of the manslaughter. Table that for a moment. But yet, in the jury instructions, culpable negligence without death is defined as a lesser included offense of vessel homicide. And so you would think that would mean it's a lower burden of proof. And so there's a significant confusion, I submit, on these elements. I've given the court the best I can find in terms of sound bites that I'd ask the court to read to the jury so they understand this is not just about failure of ordinary care or simple negligence. The concept of culpable negligence is a significant issue in this case. It is the issue in this case, frankly. And so the court, I submit, should educate the jury on that now rather than having them sit here for 2 weeks not understanding what they're looking for.
Was there anything else other than
The only other thing we raised was a motion in limine on the issue of impairment. The court recalls, I'm sure, that we've been quarreling over the issue of blood, alcohol levels, and toxicology. It all stems from the testimony 2 weeks ago of Lieutenant Thompson and providing some opinion about how blood alcohol dissipates in a case where there is no blood alcohol. And our concern that that issue is being injected into the case about impairment when there is no evidence of impairment. In fact, the evidence to date is no impairment. And so what we've asked the court to do in our motion in limine is to preclude argument and insinuation about impairment, given that there is no affirmative evidence of impairment. Indeed, the witnesses that will be testifying, by my count, there are 8 of them who observed Mr. Pino either before the elision, immediately after the elision, or during the investigation an hour and a half later. All 8 of those witnesses who I expect will testify purposely looked at Mr. Pino and observed he was not impaired. I don't know which way the state is going. They at one point said this case is not about impairment, which I understand to mean that one's faculties are impaired and affecting their ability to exercise their normal faculties. And so I would ask the court to consider that motion. I don't know if the state intends to introduce that concept during its opening statement. If not, we don't need to address it now. If yes, I'd ask the court to consider that motion ahead of the opening statement.
Okay. Would you like to respond to the request for me to give further instructions to the jury other than what preliminary instructions I gave them during voir dire?
I have a response, and I don't think that it is appropriate right now to instruct the jurors on the law, especially not on only a part of the law. When the jury instructions are given, Your Honor just simply gave the elements, which I think is appropriate, but going beyond that at this point in the trial is not. Moreover, the instructions that the defense has proposed, I'm not in a position right now to agree that the statements that they're making meet the threshold for giving a special jury instruction beyond what the standard instruction is. So I think that just as the court has reserved ruling on giving an instruction regarding the navigational rules and that all voters in the state of Florida must adhere to them, I think Your Honor should defer on these other special instructions as well, especially because they were only sent to me, I think, yesterday in the later part of the afternoon. So I haven't
There's 2 parts. Yeah, there's 2 parts of the
I
request.
understand that.
Let me clarify. We'd be satisfied for now with just the standard pattern instruction.
I think that was the first part of the request, and you responded to that. Okay. And let me say, while I understand your point, counsel, I'm not inclined to start instructing them, giving them definitions at this point. We'll come in, we're going to give opening statements. I think that whatever I instructed them on just briefly during voir dire was in order to select the jury, select a fair jury, understanding what elements of the crime are. And I think that is sufficient. I'm comfortable with that. Although I understand your request, I'm going to respectfully deny that at this time. But then you'll all review whatever the requested specials. I'll consider what you have in addition, the additional language, the red line, language. And I'm going to ask the state to look at it because the state is asking as well for special instructions because there may or may not be aspects of what we have in the standard instructions that sufficiently instruct the jury for this particular case. So you'll all be looking at that as we progress. So that's the first part. What was the next issue was the question on in limine. Now, during your opening statements, I expect that you're going to be discussing what you believe the evidence will be.
Right.
And not making any arguments about the theory of your case or how the jury suggests how they should evaluate the evidence. So I wouldn't expect to hear from the state any type of argument on what is important, what might have been a contributing factor or not, but what the evidence will be. And I think I've already addressed, at least in limine, the specific matters involving the evidence of alcohol. I think we've already done that in the last couple of weeks. So
it is my understanding, Your Honor, that the state is going to be allowed to talk about the fact that the defendant acknowledged that he had consumed alcohol and that he was seen consuming alcohol out on the sandbar.
that's going to be part of the evidence.
Yes.
So beyond that, if you have an objection, of course, anything that the state says during opening, which should be what the evidence will be, and vice versa. If you have an objection, you'll make your objections and I'll rule on it at that time.
So that I'm not interrupting unnecessarily, we have our pretrial objections. I understand the court's overruling our objection to the references, the factual references to the alcohol and the 2 beers, so that you rule that I don't need to object again throughout the trial when that comes in,
Okay, well,
as you wish.
for purposes of making your record, in terms of a contemporaneous objection, not a problem, and I wouldn't find it as inappropriate if you made your objection.
So I can have a standing objection on that issue? Very well.
So I handled all that. Okay,
One more thing, Your Honor.
yes, sir.
Good afternoon, Your Honor.
Yes, sir.
Your Honor, the defense filed several motions in limine. One of our motions in limine had to do with the exclusion of gruesome photographs and video recordings. Your Honor reserved ruling on that and said that she would take it up. We received from the state a videotape of a particular witness in this case, an officer Delgado, and one of the clips is specific with regard to the motion in limine to exclude this type of footage.
Okay, so this is, Officer Delgado,
Yes,
when
Your
he
Honor.
called as a witness for the state.
Yes, we don't know when.
Okay.
We're not told, but I did receive a video, and so I wanted to bring it to the court's attention before we got
For sure, but hold on, let me just ask the state. When do you anticipate this witness will be testifying?
Tomorrow.
Okay. I don't want to rush you, but since we have the jury outside, I'll make a note, and can you remind me, please, if there's something that objectionable in the video that the state intends to use during the testimony of the witness. Obviously, I want to look at it myself and see what that is. As I rules, if it should be, further scrubbed.
Understood, Your Honor. Would you like a copy of the videotape that I received from the state this afternoon?
I don't have a problem. Would it be okay just if you email it to me?
Absolutely. As long as the defense doesn't have an objection, we'll do that during the break.
Of course not.
Okay, that's fine. Okay. I'm making a note of that. That was, again, that was Delgado, right?
Officer Delgado, that's right.
Thank you so much, sir. Okay, I'll just call for Renee to bring the jury. Good afternoon, ladies and gentlemen. I'm going to ask Marilise, my clerk, to please swear you in as our jury. Please stand, raise your right hand and swear.
Do you solemnly swear or affirm that you will well and truly try the issues between the state of Florida and the defendant and render a true verdict according to the law and the evidence?
I do.
You may be seated, thank you. Ladies and gentlemen, welcome back. I have some questions for all of you. Have any of you seen or heard or read anything in the news that you think might have something to do with this proceeding?
No.
Okay. Have you seen or heard anything in the news about any other accidents in the water over the weekend? Or read anything about that?
No.
Okay. Have you been on social media, posted anything, read anything, online newspaper?
No.
Okay. Has anyone attempted to speak with you or in your presence about this case?
No.
Okay. All right, very well. Ladies and gentlemen, you have been selected and sworn as the jury to try the case of State of Florida versus George Pino. As you know, this is a criminal case. Mr. Pino is charged with 1 count of manslaughter and 1 count of vessel homicide, operation in a reckless manner. It is your solemn responsibility to determine if the state has proven that Mr. Pino has committed the crimes charged beyond the exclusion of a reasonable doubt. Your verdict must be based solely on the evidence or lack of evidence or conflict in the evidence and the law. As I explained to you during jury selection, this document in my hand called the information, that is the charging document. It was filed against Mr. Pino, but it is not evidence in this case, and it is not to be considered by you as any proof of guilt. It is my responsibility to decide what laws apply to this case and to explain these laws to you. It is your responsibility to decide what the facts of the case are and to apply the law to those facts. Thus, the province of the judge and the jury are well defined and do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys the opportunity to tell you what evidence they believe will be presented during the trial. I remind you what the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits may be produced as evidence. After the evidence has been presented, the attorneys will have an opportunity to make their final arguments, and following the final arguments, I will instruct you on the law that is applicable to this case. After the instructions are given, anyone chosen as an alternate juror will be released, and the remaining jurors will retire to consider the verdict. I admonish you, you are not to form any fixed or definite opinions about the merits of this case until after you have heard all of the evidence, the argument of the lawyers, and the instructions on the law. Until that time, you are not to discuss this case amongst yourselves. During the course of the trial, we will take recesses and meal breaks. During these times, you're allowed to go about your personal business. You cannot discuss this case with anyone at any point while you are still on this jury and before you are discharged. You are not permitted to let anyone to speak with you about the case or in your presence about the case. If anyone attempts to speak with you about this case or in your presence about this case, please remind them that you are on the jury. If they persist, please report that to Renee immediately. This prohibition applies to everyone in the courtroom. attorneys, witnesses, staff, and third parties. You see us at any point outside of this courtroom, we're going to ignore you. And don't take that personally. All of us, everyone in this courtroom, is invested in maintaining the integrity of these proceedings. This case must be tried by you. This case must be tried by you only on the evidence presented during the trial and in your presence and in the presence of Mr. Pino, the attorneys, and myself. You must not conduct any independent investigation. You are not allowed to visit any of the places that may be described in the evidence or read or listen to any reports that might exist about this case. You are not to discuss this case with anyone. You may not speak with the attorneys, Mr. Pino, any of the witnesses, or anyone else about this case until you have concluded your deliberations and you are discharged. In every criminal proceeding, the person accused, in this case, Mr. Pino, has an absolute right to remain silent. At no time does he have a duty to prove his innocence. From the exercise of one's right to remain silent, you may not draw any inference of guilt or hold it against him in any way. The fact that the accused does not take the witness stand must not influence your verdict or enter your discussions in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure. They have a duty to make objections they believe are proper. When an objection is made, please do not speculate as to why it was made. Likewise, if an objection is sustained, which means I prevent a witness from answering a question or prevent a piece of evidence from coming in, please don't speculate as to what might have been said or what might have occurred had the witness been permitted to answer. Sometimes during the trial, and you saw it during our jury selection, it's necessary for me to confer with the attorneys in what we call sidebar conferences. I'm going to put on the white noise. This is not for your concern or consideration. It could be a matter of scheduling. It could be a matter of law, which is for me to decide. But I call these sidebars, or they might be requested at times during the proceedings, if I think that something might take a little bit longer than a few moments, I'm going to likely take a break at that time. Okay? I also try to keep sidebars at a minimum. So if counsel requests a sidebar and I ask them to reserve, it doesn't mean I'm mad at them. Many times I can anticipate what we need to discuss, and I might ask them to reserve and then handle it when we take a break. So I like to keep them at a minimum, keeps the flow of the proceedings going. Okay? In addition, let me talk to you about note-taking. Renee is going to hand to each one of you an envelope. Now, outside the envelope, there is a tab. There's a white tab on the outside of each envelope. Inside the envelope is a notepad and a pen. Please remove the notepad and the pen from the envelope. If you would, please, write your juror number on the white tab on the front of the envelope. This is how we will identify that envelope and that notebook as belonging to you. And that is your notebook to use if you wish during these proceedings. Make sure everyone write your juror number. These notebooks are not seen by anyone else but you. It's for you to use if you wish. At the end of each session, and some at recesses, I may ask you just to leave them in your seats. If we take breaks, Renee may collect them during breaks. At the end of each session, Renee will take these envelopes from you with your notepads inside. They will be in a locked drawer in the office. No one will have access to them. Let me talk to you, though, about note-taking. I permit the jurors to take notes during the proceedings. And some people take notes, some people don't take notes. It's not a requirement. But the caution about note-taking is this. Please do not get so wrapped up or focused or concentrated on taking notes that you missed something. Because your job as jurors is to rely on your independent recollection of the evidence and testimony presented to you during the proceedings. So you have to be alert, you have to be listening, you have to be observant. So note-taking is fine as long as you don't let it distract you to the point where you're not listening, you're not paying attention, you miss something, okay? Because, again, they're for your guide, and they'll be used only to help you in recalling what transpired, to refresh your memory of what transpired during the proceedings. That's how notes can and should be used if you wish to take them. All right? Very well. Let's begin. Opening statements.
If I may just have a moment to get the seat.
Get yourself set up. That's fine.
Thank you. Your Honor, may it please the court. Ladies and gentlemen of the jury, thank you for being here. Just by way of introduction again, my name is Laura Adams. Along with me is Mr. Jonathan Borst. And also we are going to be assisted from time to time through this trial by a law intern, or law student who's interning at the State Attorney's Office, and his name is Juan Ramirez. This, ladies and gentlemen, is a case about responsibility and accountability. Or I should say, the lack of both on the part of the defendant in this case, George Pino. The evidence is going to show that on September the 4th of 2022, this defendant took his wife, his 17-year-old daughter, and 11 of her teenage friends out on his boat, and he wound up plowing right into a huge channel marker that ironically was placed in Biscayne Bay to keep boaters safe. As a result of his complete abandonment of good judgment and responsibility, 17-year-old Lucy Fernandez, her given name is Luciana Cristina Fernandez, is dead. In the aftermath of causing Lucy's death, this defendant avoided accountability by telling the police a fabrication of how this boating crash occurred. And he maintained that falsehood long after the day of this tragedy. The evidence in this case, ladies and gentlemen, will show you this was not a mere accident or a momentary lapse in judgment. The evidence that Lucy is dead because the defendant failed to do the most basic things that the rules of the water require. Things like maintaining a proper lookout. Things like operating your vessel at a safe speed for the conditions. Avoiding situations that can cause a collision, or as you may hear from time to time in this case, an allision. Collision technically means two boats striking each other. Allision is a boat striking a stationary object. Whatever term you want to use. Don't crash into things. Moreover, you are to travel when you're in a narrow channel on the right-hand side of the channel. We're not in England. We don't drive our cars on the left side, and we don't operate our boats on the left side of the channel. This defendant drove his boat after consuming alcoholic drinks that was full of teenagers who also had been drinking alcohol right into that big steel channel marker in Biscayne Bay in broad daylight, a channel marker that had a day-glow green square above it with the number 15. A channel marker that he had passed by a multitude of times because this was his water playground, going to and from a location, which I'll talk to you about in a moment, up to a sandbar. He hit that channel marker, ladies and gentlemen, as he was accelerating through the channel, going from speeds of 43 miles an hour to 47 miles per hour. He struck that steel channel marker at just under 50 miles per hour. The witness who will tell you how this crash happened has no bias, no prejudice, and no sympathy. This witness has a perfect memory. And this witness is not swayed by money or privilege or power. That witness is Global Positioning System Data, better known as GPS. The GPS from the defendant's boat is how we know the way that this crash occurred, because the GPS told the truth about what happened. George Pino did not. But before I get into the details of the GPS analysis that was done in this case, I'd like to give you a little bit of an idea of what was happening on September 4th, 2022. The defendant, George Pino, and his wife, Cecilia, had planned a wonderful weekend celebration over the Labor Day weekend. Their younger daughter, who was also named Cecilia Pino, but went by Little Ceci, named after her mom, she was going to turn 18 later that week. And so the family invited a bunch of Little Ceci's friends to come to a location called Ocean Reef Resort to have a weekend of fun, hanging out together, going out on the boat, having a celebration dinner. At around 2:52 that Sunday afternoon, they got into George Pino's boat. 12 kids, the defendant, and his wife. Before leaving for Ocean Reef Resort, before leaving the resort, however, that boat was stocked with some food and drinks. And the drinks that were stocked on that boat were not just water, were not just sodas. There was alcohol, lots of it stocked on that boat. Now the plan was to head out okay? The plan was to go from here, which is where the location of Ocean Reef is, where I'm circling this blue dot, and to traverse across this little narrow waterway, and then head up toward this location, which is called the Cutter Bank Channel. Now, for those that might not be boaters, what you'll learn in this case is that a channel is an area of the bay that's dredged out to be deep, because a lot of Biscayne Bay is relatively shallow. And if a large boat that has a keel under it has a draft that's too far, that boat's going to run aground, and that'll cause a danger to everyone. So in areas where the bay is shallow, there will be dredged out locations. And to keep people safe and to let boaters know where they can maneuver their maybe larger vessels, there are what's called channel markers on either side. They're big steel poles, and on one side of the channel there will be odd-numbered markers in day-glow green, and on the other side there will be even-number markers in red. The plan for that day was Mr. Pino went up through this channel, and he and other boats were going to rendezvous at this location here, which is called Billy's Point. It's a popular location where people will come to, dock their boats, tie their boats up to other boats, and people will socialize, have fun, sometimes drink alcohol, have food, listen to music, things of that nature. However, when they get to this area where I have the orange dot, Billy's Point, one of the boats that's kind of part of this group, it's too big to dock there. You can see where the water along here is, or this is like a lighter blue that shows shallower water. So what they do instead is they head up further north here to where I have this red dot. It's slightly deeper water, And that's where the defendant and several other boats basically stay for a few hours. Okay? So once they get to that part of the sandbar where the water is a little deeper, the plan was at the end of their time there, they were going to return back down to Ocean Reef because the defendant had planned a surprise party for his daughter. And it was going to be a catered dinner from like 9 p.m. to 11. To give you a little bit better of an idea of how the channel works, I have this exhibit also. And this gives you a little bit more of a close view of where the defendant was going to travel. So here we have where Ocean Reef is. Here is the area where he would traverse. And then this area here that I'm circling, that is called Cutter Bank. And there are channel markers, 15, 14, 13A. There's channel marker 12, all along this channel so that boats can safely travel through it. Okay? And I have one more that's just a little bit closer so you can really get an idea of where those markers are through here. And all of this evidence you'll see during the trial. This isn't your only chance. When the defendant was traveling north to get up to where the sandbar was, he was traveling at a pretty moderate speed, maybe like in the 30s or so. Also, he was navigating the boat in a way that's consistent with seeing other vessels because, again, this is Labor Day weekend, and the waters are a little busier during holiday weekends than they are, during the business day. The defendant and the kids and his wife, all on his boat, get up to the area of the sandbar at about 3:23 that Sunday afternoon. Now let's talk a little bit about what was going on at the sandbar. There, Mr. Pino dropped his anchor, and the girls that were on his boat would, hang out with each other. There was another boat that was, the owner was friendly with Mr. Pino. He had some boys on his boat, so the girls and the boys were swimming back and forth with the boats, listening to music, having a great time. They would hang on to floating devices, interact with each other, and yeah, they were drinking. The teens on the boat, on Mr. Pino's boat, helped themselves to alcoholic drinks that the Pinos provided. The adults kind of knew what was going on, and the thought was, look, if kids are going to drink, it's better if they're drinking in the company of hopefully responsible adults rather than do something on their own. But the teenagers weren't the only ones that had consumed alcohol that afternoon. So did Mr. Pino. This was really one big happy party. Here's a picture of most of the girls that were there that afternoon. Many of these girls knew each other from elementary school. What a great day this would have been. Oh. This girl here, in the white bathing suit with the cute little flowers, that's Lucy. At one point that afternoon, Lucy's mom and dad, who were also at Ocean Reef, had been asked by their daughter, "Mom, Dad, come on out to the boat. We're going out with the Pinos. Come meet us out at the sandbar." Now, Lucy's dad, who you'll meet during this trial, he was kind of tired. He had golfed earlier in the day, but he and his wife figured, If your teenage kid is saying that she wants to see you, even when she's with a lot of her friends, let's suck it up, let's go. We're gonna go see our daughter. And so Mr. and Mrs. Fernandez took their own boat out and wound up rendezvousing with where the Pino boat was and a couple of the other boats that were there. What you'll learn is that Mr. Fernandez didn't really want to stay a very long time because he had plans later that day to watch the game between FSU and LSU with his dad who lived at Ocean Reef. So his plan was to go out there, see his daughter, engage with the people that they all knew, and then try to leave by around 5:30 or so that he could be back in time to clean off the boat, get cleaned up, and then go over to his dad's condo on Ocean Reef. While Mr. Fernandez is there, he too consumes some alcohol. He winds up toward the end of the day getting ready to leave. And as he and his wife are getting ready to leave, they kind of thought about what a great afternoon it had been. They were glad that they'd gone out to see their daughter. At one point, their daughter swims over to the boat, and she asks her dad for some sunscreen and a hair tie, to make a ponytail with her hair. She hugged her dad before jumping back off the boat, and that was the last time Andy Fernandez ever got to hug his child. Before leaving, Andy took this picture with his phone. You can see this is the defendant's boat. You see people floating around. You see people on the boat. What could have been more fun than being lucky enough to be out on the waters, to have a weekend at Ocean Reef with friends that you've known practically your whole life? What a magical day this could have been. Now, they were there at that sandbar for almost 3 hours. And the evidence is going to suggest that perhaps Mr. Pino overstayed the time that he wanted to be there. Why? Because when he starts getting the girls to rendezvous back onto his boat, 12, 17-year-olds plus his wife and him, he leaves the area here, where they had been, and begins to traverse back down south, where he's going to traverse through Cutter Bank Channel to get back to Ocean Reef. Why? I told you about him having a party planned. This was the invoice for that party. It was to go from 9 p.m. to 11 p.m. It was going to be a custom buffet with salads, mini burgers, chicken, all of this kind of stuff. It was an outdoor venue that was going to be catered, and it was supposed to be a great time. But, my goodness, yes, 12 teenage girls that are going to need to get showered, get their hair dried, get ready to go out for this event. Now, these girls were staying in a home that the Pinos had rented for that weekend. It wasn't like some gigantic mansion. So what winds up happening is, as he's heading back toward Ocean Reef, he is going faster than when he was going up there. And when he was going up to the sandbar, we know from the GPS that he was kind of circumnavigating things like this. What we know from the GPS is that when he was coming back, he was doing a lot more straight through traveling. Now, the waterways, of course, are different from the roadways. We don't have speed limit signs in the same way on the water that we have on land. But there are rules that are to be followed. Even if there is no speed limit,
one of the rules is that you must operate your vessel at a safe speed for the conditions. I already talked with you about the fact that there's a rule you are to operate your vessel on the starboard or right-hand side of the channel. George Pino operated his boat on a plane, which means that it's basically just skimming the surface of the water. He's gotten so fast that the boat is just traveling on top of the water. He's operating it on the port side, meaning the left side of the channel, not the right. And as he was going through that channel, heading back to Ocean Reef, just as he had his GPS on the way up, his GPS was on the way back. The GPS on his boat tracked his every move, his direction, when he changed direction, and it tracked his speed. The GPS on his boat was like a silent witness, watching and recording his every move. So you'll learn in this trial a little bit about how GPS works. For now, I will just leave you with this. Properly interpreting it can tell you moment by moment where the boat is going, how fast it's going, and how long goes by from one time when you change direction to the next time you change direction. So what winds up on the way to, yes, this is the GPS data that we have from the defendant heading, before he leaves, heading up this way to where Elliott Key is, and then you see these little, like, track mark, these little blue dots, those are track marks. Those show every time the boat is being changed in direction. This is where he originally gets to, at Billy's Point, but it's too shallow for one of his friend's boats to be there. So he heads up, further north, until they get right here. Then, and he gets there at about 3:47. From there, the GPS is turned off because the boat's anchored. What do you need your GPS for? At 6:18, the GPS is fired back up again. And we know, track mark, he's navigating his way through here. And now look at what we see here. Straight lines, track mark, straight line, track mark, straight line. A very different driving pattern to get back than to get up there. So what do we know happens once he starts entering into Cutter Banks? We know that he is going straight down this way, right? There's a channel marker here, channel marker 14. Here is channel marker 15. This would be the channel, and he's hugging the left side of that channel. And what we know is that before he gets to channel marker 15, right, at 6:37 and 28 seconds, he has his last track mark. That's the last time he changed direction. And what did he do? He tried to avoid channel marker 15 right here. But it was too late. Let me back up a bit. So here we see the defendant's track lines heading up, and here he is coming back on the return track. And we see one track point here and one track point here, which is less than 30 feet away from where that channel marker is. And what we know is that when he leaves this track mark, he was going 43 miles per hour. This last track mark, right before he hits the channel marker, he's going 47 miles an hour. He's literally accelerating through that channel. What is this? All these little track marks here? This is after his boat crashes into the channel marker. Because he was not wearing a thing called a kill switch, which you attach like to your waistline or something so that if you get ejected from the boat, it kills the engines so that nobody will get chopped up by a propeller. Thankfully, even though he was not wearing a kill switch, which is why we see the boat is still moving because the engines are still running, thank goodness nobody got chopped up in this case. To give you an idea of what it looks like for a 29-foot center console vessel to smash into a steel pole as fast as George Pino did, what you'll learn in this case is that we'll have to talk like sailors a little bit in this case, all right? So starboard and port, right and left. So this is the starboard side of his boat. And what happened is he initially hits with the front of the vessel right here called the bow. Boats, unlike cars, are not made of metal. They're made of fiberglass, which is plastic. And unlike metal that crunches and crashes, plastic flexes. So when he first hits that, the boat flexes. And what winds up happening is the boat rides up on the channel marker and literally is gouged open by the board that's at the top of that channel marker that says 15. And it rips the boat right open. When it comes to the other side of the channel marker, it's taking on water like crazy through this gigantic, gash mark in the boat. And as the boat is in the water and taking on all this water, it flips upside down. This is a picture of the vessel at final rest. You can see that huge gaping hole in the boat. Now, in the aftermath of this crash, it was chaos. The only person who was keeping a lookout for this vessel was the defendant. His wife, who was seated next to him in the center console, she was on her phone. The kids were all thinking that George Pino's going to get them home safely. They're not keeping lookout for danger. This all came as a shock to them. It should not have been a shock to the defendant because the evidence will show that 9 seconds prior to impact, George Pino changed direction just 5 degrees to port, just a little nudge to the left side of that channel. And when he did that, he was on a complete collision course. An absolute collision course with where channel marker 15 is. For 9 seconds, from this moment, when you're out on the water, as you'll learn in this case, you can see that channel marker ahead of you, if you're looking. For 9 seconds, he never changes direction. He smashes right into it. And to give you an idea of how long that is, that's how long he was on a collision course with that gigantic steel pole. After the boat hits the channel marker, some girls are ejected from it, some girls jump off the boat, but there are now 14 people in that water. One by one, the girls who are not too badly injured try to seek out and find their friends. The defendant's wife, same. The defendant, though, he just kind of holds on to the front of his boat, which is now upside down, and the anchor of his boat has become the canopy, because the canopy of his boat is now on the bottom of Biscayne Bay. One by one, they're trying to account for all the girls. Where's Ceci? Where's Katy? Where's Mia? Where's Caro? All these girls. And eventually, through all that chaos, there are some that are not conscious. There are some that are borderline conscious. Everybody is accounted for, but one. They're looking and looking. Where's Lucy? Where's Lucy? Somebody yells to the defendant, still holding on to his boat. Look under the boat. Maybe she's trapped under there. She was. The injuries she sustained were not great injuries, but she didn't die from those injuries. She died because she drowned. She was underwater, unconscious, and she drowned. When Lucy's body is found, she's brought up onto a Good Samaritan boat. Because this was Labor Day weekend, there was a fair amount of vessel traffic out there. And without too much time going by one, Good Samaritans came and tried to help get all these people out of the water. When Lucy was brought on board, there were people on that little boat who started performing CPR on her. People start calling the police for fire rescue, for help. Now, it's tricky to give your exact location when you're on the water if you don't know how to give your coordinates, because it's not like you can look up and say, oh, I'm at the intersection of 12th Avenue and 14th Street. So sometimes it takes a little bit longer for first responders to get to the scene of a boat crash. Well, when the first responders get there, they know that Lucy is in dire shape. You'll hear that one officer, when he approaches, he's seeing a helicopter from above, which is trying to lower a paramedic onto the boat that Lucy's on. But the problem is the boat Lucy's on isn't very large, and the wash from the propellers is starting to make that boat spin. So he has to nudge his police boat up against the boat Lucy's on, and another officer has to do the same to keep the boat steady enough that it will be safe for the paramedic to come onto the boat. Once the paramedic is on the boat, they load Lucy up onto a backboard, and they transfer her to another boat. And then that boat takes off for this location here, Elliott Key, which is a long, really narrow island. And right about in the middle of it, there's a ranger station. And that's a place where it would be safe for a helicopter to land to then take Lucy to a hospital as fast as possible. Well, all along the way that they are trying to get her to Elliott Key, the officers are taking turns doing CPR on Lucy. The fire rescue guy is trying to intubate her. They're trying to get her heart pumping so that blood and oxygen will get to her brain. As you can imagine, a scene like this is pretty chaotic. The man who is tasked with the responsibility of managing this chaos is named William Thompson. He was, at the time, an investigator with the Florida Fish and Wildlife Conservation Commission, better known as FWC. Since the time of this crash, he's been promoted, and he is now a lieutenant. Lieutenant Thompson was responsible for coordinating with all the different responders that came to this scene. Officers from the Miami-Dade Sheriff's Marine Patrol Unit. There were Coast Guard officials that came to the scene. There was other fire rescue units that came to the scene. There's the management of finding out who's injured, what's the level of injuries, conducting that kind of triage, figuring out what hospitals different people are going to go to. And beyond that, he also needed to find out what happened. How did this happen? The girls really couldn't give him any information. They're not paying attention, because what you'll learn is that on the bow of the defendant's boat, up in this area here, there was a girl sitting on every seat available. The defendant and his wife were sitting at the center console, and there were two girls that were seated in the back. These girls up front, their backs are to what's coming up ahead of them, and they're hanging out with each other, so they can't really tell what happened. And the defendant's wife was playing on her cell phone. So the only person that Lieutenant Thompson could try to find out how did this crash happen from was the defendant. Now, the defendant himself, for sure, got banged up. He had a cut to his head, a cut to his elbow. I think some of his teeth were, knocked around a bit. But overall, he was okay. He'd been checked out by police officers, fire rescue. He was ultimately transported to Elliott Key, which is where they brought all the other girls that were not tremendously injured. And there, Lieutenant Thompson winds up trying to find out from the defendant what happened. He could find out what happened from the defendant and from the GPS. And like I told you, the GPS told the truth, but he did not. When Lieutenant Thompson is interacting with the defendant, he's wearing what's known as a BWC, a body-worn camera. It's right on his chest. And while he's talking with the defendant at a picnic table that's there, the defendant is seated across from him. Now, you can't really see his face because it's like from chest to chest level, right? But you can hear what's being said. You'll hear the way that Lieutenant Thompson was speaking to the defendant in a calm way, just trying to find out what happened. Because at that point in time, there's no indication that this is a criminal case. They just need to figure out what the heck happened. So as they start talking, the defendant starts explaining himself. But the way he does it was an abdication of his responsibility and accountability, because the evidence in this case is going to show that what he said happened did not happen. What he did to avoid responsibility and accountability is he told this story to Lieutenant Thompson that there was this other vessel that had thrown a big wake in his way. And to keep his passengers safe, he had to try to attack through the wake, like taking evasive action. But we know from the GPS, which Lieutenant Thompson didn't have at that moment, he was on a straight course. I showed you. It was for 9 seconds straight ahead. There was no other boat. He made this up because he didn't want to be blamed for what was clearly his fault.
Judge will reserve a motion.
So, when Lieutenant Thompson asks, how did the crash happen? The defendant tells this story about what the evidence is going to suggest is a phantom boat. Now, clearly, nobody's going to be fully in charge of their rational faculties after a horrific event like this, whether it's your fault or not. This is a really stressful thing for anybody to go through. And he was injured. But he was alert. He was able to walk around. He was able to be responsive to questions. When the defendant told this story of the phantom vessel, he then was asked, would you give a written statement about what happened? This is what he wrote. Going back to ORC, Ocean Reef Club, through channel, past boat on left side of my boat, veered to the right to avoid big waves. Coming back into the wave, I lost control of steering wheel as boat was going through the big waves. I was ejected from the boat. That's what he said happened. He said it in more detail orally to Lieutenant Thompson, but that's what he wrote. And even when the GPS proved that he was wrong, he doubled down on the things he said to Lieutenant Thompson. Because in the aftermath of this crash, there was a lawsuit against the defendant. And you'll learn that in civil lawsuits, one of the things that happens is a civil attorney may say to the person that they're suing, tell us about how this crash happened. And that kind of a document is called an interrogatory. And when you answer an interrogatory, your answer has to be under oath through the penalties of perjury even. And when he was asked in this interrogatory, how did this crash happen? You know what he said? What I said to Lieutenant Thompson, that's how the crash happened. How did the police wind up getting this GPS data? Well, in an effort to appear cooperative with the police, the defendant signs a form giving them consent to go on his boat and take from it the SIMRAD, that's the brand name of the chart plotter devices or the multifunctioning displays that he has. It's not completely unlike CarPlay, if anybody uses their Apple phone with their car, where you can scroll through different maps, charts, things like that. The defendant gives permission for that. And those SIMRAD navigational devices are then brought to a man who is, number one, a former FWC officer. Number two, is currently a lieutenant with the Town of Palm Beach Police Department as an internal affairs supervisor. But also, number three, is a maritime expert who testifies regularly in the field of safe navigation, safe boating requirements, and also in how to download and interpret GPS data. His name is Paul Albert, and you will hear from him about how GPS works, how he was able to extract GPS data from the defendant's boat, even after it had been upside down and underwater until they could salvage it and bring it back to shore. He will tell you unequivocally the defendant's boat took no evasive action to avoid striking that channel marker. There was no other boat in that vicinity. The defendant said that there was another boat, which is clearly disproven. He also told Lieutenant Thompson that he had 2 beers while he was out at that sandbar. Now, it would not be practical for you all as jurors to go out to the scene of this vessel crash and feel for yourself what it's like to go 47 miles an hour through that narrow channel on the wrong side of it. So Lieutenant Thompson and Mr. Albert did the best that they could to try to recreate it for any jurors that might be on this panel, whether you have experience boating or not. What they did was, using buoys and GPS points, they dropped one buoy in the Cutter Bank Channel where the second to last track point is, and one right before the last track mark, which is less than 30 feet away from where that channel marker is. They then had Lieutenant Thompson take his police vessel, which, like the defendant's, is 29 feet, has a center console, and has two 300 horsepower engines. And what he did was he then began coming through the channel, and by the time he got to where that second to last track mark is, he was going 43 miles an hour. He then continues to accelerate his vessel until he's at 47 miles an hour, and at the last second, swerves to avoid hitting the channel marker. To give you an idea of what that's like, we had a veteran crime scene detective with the sheriff's office come out on a Marine Patrol boat and launch a drone that then could film the boat as Lieutenant Thompson piloted it through the channel. In addition, a GoPro camera was affixed to the front of Lieutenant Thompson's boat so that jurors could get an eye view of what you could see if you're looking and when you can see that channel marker up ahead. In addition, a GoPro camera was attached to the actual channel marker so that you could see that same approach as Lieutenant Thompson comes right up to it and avoids hitting it at the last second. Now, lest you think that the police did all of this without concerns for safety, you will learn that during this exercise, there were marked police boats on the north and south end of the channel to make sure no vessels were going to be in that area. Plus, we had the Marine Patrol boat that the detective had launched the drone from. Plus, as Lieutenant Thompson was going through this channel, he had his police lights activated. In addition to that, everyone that was on board his vessel for this exercise was wearing a life jacket, or what's called a PFD, a personal flotation device. When you see this footage, you will realize that traveling 45 miles an hour through waters, even when they're calm, is nothing like going 45 miles an hour in a car. Boats are not encased in steel like cars are. They're not equipped with anti-lock brakes. They don't have seat belts or airbags. One mistake on the water can cause absolute catastrophe. Oh, and also, before this exercise, Lieutenant Thompson did not consume 2 beers. Now, although we can't take you to the scene of where this horrible crash happened for safety reasons, because you can't predict what the weather's going to be like during a trial, you will be taken on a field trip to the Florida Fish and Wildlife Office, where they have a yard that they can store vessels that have been involved in crashes. And you will see with your own eyes this very boat. You will see the horrific damage, and you will be able to see for yourselves that anyone at the helm of that vessel, looking straight ahead, would easily be able to see a huge steel channel marker with a day-glow green board at the top of it. There's no evidence to conclusively prove that George Pino was drunk. He's not charged with boating under the influence, causing a death. There's no evidence that he deliberately crashed his boat into that channel marker. If the evidence supported that, he wouldn't be charged with manslaughter and vessel homicide. He'd be charged with murder. But the evidence does support a finding that traveling through that narrow channel at the speeds that he was, with as many people on his boat as he had, people who had been consuming alcohol, people who were 17 years old, and not looking where the heck he was going for 9 seconds. People won't even drive blindfolded for 9 seconds. They sure as heck should not be operating a boat with a blind eye. The evidence in this case will show conclusively this was not just an accident. This was a bunch of factors that, when they all come together, formed the inescapable conclusion that George Pino was reckless and he was culpably negligent, and as a result, Lucy's gone. And that's why at the end of this trial, I will ask you to return a verdict of guilty.
Maybe approach with the motion before I start opening.
Sidebar? has the burden of proving each and every element of the crimes that are charged. The defense has no burden whatsoever to prove or disprove anything or present any evidence whatsoever. Thank you. Mr. Shelley.
Good afternoon, ladies and gentlemen of the jury. Can everybody hear me okay? Is the microphone working, Your Honor?
I think it is.
I think we all agree that we're here today because there was a tragedy. Lucy died. And it's painful. It's painful for everybody to think about it, hear about it, talk about it. And over the course of the trial, we'll have to relive those moments. And George Pino is going to have to relive those moments. He loved Lucy. He'd known Lucy since she was a little girl. He loved Lucy like a daughter, like his own daughter. The state admits this was not George's intention for this to happen. He did not intend to crash into a marker. He did not intend for anybody to be hurt. His own daughter, his own wife, his own body was on that boat. He had traveled on that boat safely through that channel many, many times. Many times. And he was celebrating his daughter's 18th birthday with some of the best friends his daughter had since childhood. These were generational friendships. George's parents' generation, George's generation, and then the next generation. George would never think to put any of these girls' lives in jeopardy. And when he was traveling at 47 miles per hour, with everybody seated on that boat, with George at the helm, a perfectly clear day, the seas were calm. A boat like that could have been powered not with just 600 horsepower engines, but 700 horsepower engines, although George didn't put the maximum horsepower engines on that boat. That boat can travel at upwards of 50 plus miles an hour, fully loaded. There was no weight restriction or personal restriction that George was violating when he had all of his passengers on the boat. There was a life preserver for each and every one of them on board, although the law doesn't require that passengers on a boat wear the life preserver. There was no speed limit in the channel. And there are channels with speed limits. When you come back to port, you might see a sign that says, no wake. Wake, W-A-K-E. Boats have to travel slowly when coming back into port sometimes. There might be a marker that says minimum wake. And there are markers that have speed limits throughout the intracoastal waterway. But Cutter Bank Channel in 2022 had no posted speed limits. We are now in 2026. There are still no posted speed limits at Cutter Bank Channel. Even after this tragedy happened, our legislature has not imposed.
Objection, argument, sustained.
There was none then. There is none now, because under ordinary circumstances, traveling at 47 miles per hour, which George Pino had done many times, is not a violation of the law. It is not unsafe seamanship. Still, George crashed. The state's theory, as you've heard it today, is a bit of a mishmash. On the one hand, they say to you 2 beers, trying to suggest to you this is about alcohol impairment. The state knows better than that.
Objection, argument.
The evidence will show.
What the evidence will show. Thank you, counsel.
I apologize. multiple eyewitnesses, at least 8, I expect, will testify at this trial, 8, who observed George Pino at the sandbar just after the collision, the crash, and law enforcement officers themselves who observed George Pino eye to eye, examining him purposely to determine, was George Pino impaired? Each of those witnesses who examined and observed George Pino were satisfied that George Pino was not impaired. That included the adults that were at the sandbar. It included Lucy's dad, who was at the sandbar, himself enjoying the festivities with his daughter, with the Pinos, and with the other families that were there. And the adults that were at the sandbar were also consuming some alcohol. They too operated their motor vessels after consuming some alcohol, including Lucy's dad. Lucy's dad would never have allowed his daughter to ride back with George Pino if Lucy's dad thought that George Pino was impaired. And Lucy's dad saw that George Pino had had a beer and was satisfied that George Pino was not impaired. This was not the first time George Pino had had a beer in his life. So you'll hear testimony from the adults at the sandbar, including George Pino's wife. George Pino's wife was on that boat. She would not have allowed her husband to operate a boat with her own life, her daughter's life, and the lives of the girls that Mrs. Pino had helped raise. Some of these girls grew up in the Pino home all the time, spending time together. Mrs. Pino will testify. George, her husband, was not impaired. She wouldn't have risked her own life.
Excuse me. Can you come sign both? Thank you.
Your Honor, I apologize to counsel. I have no intention of trying to interrupt his opening statement, but the defendant's emotional outburst became unavoidably distracting and wholly improper for a jury to view. Okay, I know it's not counsel's fault.
I'm going to take a few minutes break. Mr. Pino. And then we can do the whole discuss how that can be accomplished, because we are going to proceed, and Mr. Pino is going to need to be able to control himself. 10 minutes, thank you. We go out this floor.
Sorry, that's it.
was outside there is when I understood it. That's right. Normally I would pull the alarm.
They don't need to be reset?
No.
Okay.
Oh. Okay. Finish. So let me just speak with everyone. Mr. Pino, it's okay. Catch your breath.
May we approach lawyers to be your
my observations of Mr. Pino, it's my request that he be examined to make sure he's not having an event that could be more problematic. I don't think he's well, and I don't think he's in a condition to make a decision. And Your Honor is suggesting I welcome the offer. I think someone should examine him. I don't think I'm competent to give an opinion about his health situation.
Okay, well, I had offered the option, I want Mr. Pino to verify me. Okay, and fire rescue was already here, and understood that there was a brief examination. We'll have them come back, but what I had offered as an option, which we have live stream right next door, and Mr. Pino is online, and he can sit there until he feels more comfortable. I'll let the jury know that, so that we can continue with our proceedings. That was the option I offered. Or we can continue, Mr. Pino is still here, but if Mr. Pino felt emotional again, then it's not proper for the jury at all to be witnessing, the emotional behaviors.
I agree that the jury should not have to observe that. And so what I'm asking is whether we can have him examined before we continue with the proceeding, so that if there's a serious medical issue, that we're not just assuming that it's appropriate to remove himself to remove himself from the
I
courtroom.
understand. And for the record, he was asked
Right.
10, 15 minutes ago, and if you have some concerns that, he needs that additional assistance, that we're going to make a call again and have them come. Even if Mr. Pino says he doesn't want them to come, now we're going to have them come. We're going to have a medical assessment of Mr. Pino before that procedure. Okay. And we'll be in recess until, I would say, let's take 15, 20 minutes, and we will be back, and I'll advise everyone how we're progressing. Okay? Thank you. and gentlemen, we'll go back on the record now. Jury will be coming back in a moment. We are going to suspend the proceedings today. We will resume the proceedings tomorrow at 9:30. The question is going to be whether it's in this courtroom, since apparently, not only did we have, apparently there was a 6.1 earthquake in Cuba while we were all out there. There also is an issue with the air conditioning in the building, as you probably could tell, and I'm not sure if it's just affecting this side of the courthouse. So, we may or may not be in session in this courtroom tomorrow, or in another courtroom on the other side of this hallway. There's several courtrooms available on the other side of the hallway. But what that would mean is, ladies and gentlemen, that we would have several other courtrooms available for...
All right.
Hold that thought. Please be seated, thank you. Ladies and gentlemen, I apologize for the delay and thank you for your patience. I'm sure Renee is taking good care of you with snacks and coffee, which will keep them coming. However, we are going to suspend the proceedings for today. We will resume the proceedings tomorrow at 9:30 in the morning. I do not know if we're going to be in this courtroom or if we're going to be in the courtroom I usually use, which is 4-6. One of those two, because there apparently is also an air conditioning problem in the building, if you haven't felt it already. We don't know if it's the entire building or just this side. So, we have your information, but you are expected to return tomorrow at 9:30. Please be mindful of my instructions about not looking for anything or any information outside of this courtroom about this case. You have heard no evidence. So please do not become an investigator. Do not go in social media. Do not talk to each other about this case. Do not speak with anyone about this case. If anyone has a question, I'm on a jury, I can't talk to you. Those are the responses. And if there's further inquiry, you send them to me. Right? If anyone attempts to speak with you or in your presence about this case, please remind them you're on the jury. Always wear your juror badges well displayed, and even during breaks, because I think there's one main kind of eating area down the street. I'm on my bearings here, but you should wear your juror badges really the entire time that you're within the vicinity of this courthouse and you're doing your work here. Okay? If you see anything in the news, ignore it. If you think you see anything in the news, ignore it. Okay? Tomorrow when you return, please return to the jury room. As we have it, you'll meet Renee up there again at 9:30. As you're leaving now, if you would please put, if you haven't already, your notebook inside the envelope. And you're going to give Renee the envelope, and he's going to store those envelopes for you. Make sure your jury number is on the front of the envelope. Again, the parking is taken care of. Renee, if there's any other instructions, you speak with them. And again, tomorrow, 9:30, jury room, 7th floor. Have a pleasant and restful evening.
All rise, bring your yellow envelopes with you. Follow me.
Everyone be seated, thank you. Oh. I'm trying to coordinate all these different things happening. So whatever sentence I was on was in the middle of it, but I think you got the rest of it from what I was explaining to the jury. So we're intending to continue with the proceedings tomorrow here at this courthouse, unless I hear something else. In terms of providing that information, as soon as I get the information, I'm going to extend it and make sure the attorneys and everyone knows. But I'm hoping to be back in this courtroom tomorrow. If not, we're going to make arrangements if we can hopefully stay in this building to work on the other side of the building. And we'll set up several courtrooms if needed for whoever wishes to be present. Might not be in the courtroom we're working in, but you'll have the entire proceedings. You'll be able to observe them through the live stream. So I expect that that's what's going to hopefully happen, and I hope you all have a pleasant evening. Thank you very much.
Jesus be with you.
Yeah, why don't we do that? Yes. Well, that's my chamber. Yes, we're back here. And then we'll talk about all that.
Deja los cables aquí.